What's happening, Internet fam? So I got a notice the other day from the opposing side in my 3+ year ongoing custody battle for two innocent children who have done nothing wrong. And by the way, I'm their dad, and I've also done nothing wrong. I do have some parking tickets, so there's that. And so I formulated a response, and I figured I'd go ahead and read the response to everybody in case they were interested. I don't know. Some people are following along. If you're interested, great. If not, just turn it off, okay? This is my response to notice of limited appearance. It is incumbent on the court to allow the plaintiff to be represented in all matters regarding the welfare of his two small children, Everett and Grace. Myself being the plaintiff, because once again, I've been denied access to my children for 3 years, so I'm trying to just be a good dad and just be in their lives at all. The defendant has repeatedly used legal complexities and loopholes to deny visitation of the children with their father in 3 states since March 2017. This notice of limited appearance, which is what my response is formulated about or around, filed April 30th, 2020, appears to be more of the same. Defendant has continuously and substantially violated all visitation orders given by every court in every state. That's true. I would love to provide evidence for all of that if I actually could be allowed to provide evidence for all of that. Plaintiff has not seen his children for months. Again. Defendant refuses to correspond in the Talking Parents app, ignoring questions about the children's health and safety and refusing to schedule video chat visitation. Defendant's attorney refuses to respond to emails regarding notice of limited appearance specifically. Defendant's attorneys also refuse to negotiate any type of reasonable visitation or even set parameters for how that type of negotiation could be pursued. Should the defendant's attorneys have access to the court or the judge without the plaintiff's involvement or awareness, this is a clear violation of the rule of law and violations of the plaintiff's parental rights, as well as a continued violation of the children's rights. Plaintiff has only had very limited access to the children via phone since early March 2020. This is a continuing violation of the existing order. Defendant refuses to offer video chats, which both the children and their father clearly prefer, and only allows phone calls at low volume, often with loud auditory interruptions in the background, including defendant or some Navy guy interrupting both the children and their father, loudly speaking over them and making the calls stressful and often short-lived. Plaintiff would again like to point out that the defendant exhibits several prominent characteristics of strong personality disorders that are well documented by experts in the field. In particular, she is both bipolar and a narcissist, as well as exhibiting a high level of sociopathy, including the continued violation of court orders in 3 states now. Plaintiff also would like to point out that the defendant continues to be openly hostile to the plaintiff despite having almost complete control of the children due to a corrupt judge in California who was a close associate of the defendant's father. Plaintiff discovered these facts long after the trial. Once again, plaintiff would like to point out that he has virtually no criminal record, no history of violence, and has maintained gainful employ consistently despite the efforts of defendant and defendant's counsel and the state of California to make this impossible, and also despite being laid off due to COVID-19 twice. Plaintiff would also like to reiterate that despite no accusations of violence, no criminal record other than parking tickets, and no mental health issues, he attended an anger management course, underwent a psychological evaluation, and has also moved from state to state to state in an effort to be the best father possible to 2 young and innocent children that now live with a 4th Navy guy in the last 3 years, who has also been a party to the horrendous child abuse, parental alienation, visited upon Everett and Grace. Plaintiff would also like to remind the court that the defendant has multiple DUIs and has never held a job for an entire year other than when she worked for her own uncle, largely due to her obvious and extreme personality disorders and drug and alcohol abuse. Plaintiff would also like to point out that the defendant's last significant employment was at a marijuana dispensary, where the plaintiff did witness the defendant and other employees intoxicated and smoking copious amounts of high THC marijuana in the form of dabs. Plaintiff and many others witnessed the defendant repeatedly drive while intoxicated, often on drugs and alcohol, despite already having obtained not one, but 2 DUIs. Once again, the defendant has successfully made any visitation impossible for months and refused to negotiate even a modicum of communication, either via Skype or other means. The plaintiff has now secured yet another high-responsibility job, a nice apartment, a new circle of friends, and a third state. This is the third time since the defendant forced the plaintiff to file for divorce by sleeping with multiple partners, all of whom abused drugs, alcohol, and failed to maintain a reasonable employment record. The plaintiff merely asks the court to uphold the existing visitation orders and drastically penalize the defendant for her willful and continued child abuse, violation of court orders, inhuman cruelty, and other malfeasance. The plaintiff will continue to seek legal recourse until such time as a 50-50 shared custody arrangement is guaranteed and enforced by the state. Plaintiff will continue to do so for as long as he breathes, or until Grace turns 18 in December of 2031. Plaintiff has been desperately trying to gain any visitation or custody in Hawaii since December 2018. It's now May 2020. And still, the bipolar alcoholic defendant is continuing to violate court orders without repercussion, while simultaneously harassing, hassling, and otherwise abusing the plaintiff. And this is after the plaintiff struggled and paid thousands of dollars in California to get minimal visitation, which was also violated by the defendant, including a 6-month period wherein she did not allow the plaintiff to have any contact with his 2 children, for whom he had been the primary caregiver of for more than a year, during which the defendant was driving drunk and doing dabs in Coos Bay, Oregon, while working at Stoney's, and going out drinking after work with all manner of nefarious losers, including a heavy metal drummer who ran a burlesque. Yet still, over 3 years later, there is not a viable or enforced shared custody order. Still, 3 years later, the children do not have access to a loving and caring father who is a classically trained violinist, speaks 3 languages, and is highly focused on organic fruit and vegetables. The children are sequestered on a military base with their bipolar alcoholic mother and her 4th military paramour in the last 3 years. So I just submitted that to the court today, and if you would ask me if I have much hope of it achieving anything at this point, 3 years on in the process, I'm not optimistic. But I will never stop fighting for the rights of 2 innocent children who deserve to have at least one parent who's sober and coherent and not a psychopath.